So today we are going to discuss about criminal law. So this video will be focused only about the introduction of the criminal law. So I will be using two books for this video. The book of Luis B. Reyes and the book of Judge Abudiente. So without further ado, let us start our discussion. So first, we need to define what is criminal law. So basically, criminal law is a branch or division of a public substantive law which defines crimes, threats of their nature, and provides for their punishments. So, why is it that criminal law is a public substantive law? Simply because it defines and deals with the relationship between the individual and the state and dictates the norms on how the individual should conform with the statutes promulgated by the competent authorities. So penal laws are substantive laws because it grants, defines, and limits the state's right to inflict punishment upon the erring individual. So a law is penal in nature if it defines an act or omission and imposes a penalty for committing or omitting to do such act. And now let us proceed in the definition of a crime. So what is a crime? So a crime is an act committed or omitted in violation of a public law, forbidding or commanding it. And now let's talk about the sources of Philippine criminal law. So there are three sources of our criminal law. So the first one is the Revised Penal Code, or the Act number 3815 and its amendment. The second one is the Special Penal Laws passed by the Philippine Commission, Philippine Assembly, Philippine Legislature, National Assembly, the Congress of the Philippines, and the Batasang Pambansa. And the last one is the Penal Presidential Decrees issued during martial law. Court decisions is not included as a sources of a Philippine criminal law simply because court decisions merely explain the meaning of and apply the law enacted by the legislative branch of the government. So under the Latin maxim nullum crimen nulla poena sine lege, no criminal liability can be incurred no matter how reprehensible is the act or omission, even if the act is socially or morally wrong, unless there is a penal law which defines and punishes the act. This is so under our jurisdiction since there are no common law crimes in the Philippines. So basically, it means that there will be no crimes unless there is a law, or no crime without the law, because the Philippines because there are no common law crimes in the Philippines. So these so-called common law crimes, which is known in United States and England as a body of principles, usage, and rules of actions, which do not rest for their authority upon any express and positive declaration of the will of the legislator. And now let us proceed to the power to define and punish crime. So who has the power to punish or define the crime? So basically, the state has the authority under its police power to define and punish crimes and to lay down the rules of criminal procedure. Why? Because it is the state that punishes crime because it has the monopoly of the public forces. And now let us discuss the congressional limitation to pass legislation. So there are also a limitation in making or in enacting a penal legislation. So some of these limitation includes the following. So number 1, no ex post facto law or bill of attainder shall be enacted. This can be seen in Article 3, Section 22. And then number 2 is that no person shall be held to answer for a criminal offense without due process of law. This is found in Article 3, Section 14, Paragraph 1. Now let us first define what is an ex post facto law. So the first limitation which prohibits the passage of retroactive laws which are prejudicial to the accused. So this is what we call the ex post facto law. So an ex post facto law is one which makes criminal an act done before the passage of the law and which was innocent when done, and punishes such an act. Number 2, it aggravates a crime or makes it greater than it was when committed. Number 3, it changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. Number 4, it alters the legal rules of evidence and authorized conviction upon less or different testimony than the law required at the time of the commission of the offense. Number 5, it assumes to regulate civil rights and remedies only, in effect imposes penalty or deprivation of a right for something which when done was lawful. And the last one is it deprives a person accused of a crime some lawful protection to which he has come entitled, such as the protection of the former conviction or acquittal or a proclamation of amnesty. And then the next one is the Bill of Attainder. So the Congress is also prohibited from passing an act which would inflict punishment without judicial trial, for that would constitute a Bill of Attainder. So basically, a Bill of Attainder is a legislative act which inflicts punishment without trial. Its essence is the substitution of the legislative act for a judicial determination of guilt. So, example of a Bill of Attainder is when Congress passes a law which authorizes the arrest and imprisonment of communists without the benefit of judicial trial. And so, the second limitation also requires that criminal law must be of general application and must clearly define the acts and omissions punished as crime. And now let's talk about the constitutional and statutory rights of the accused. So, I will no longer explain this on detail. I will only give a specific article under this topic. So, for constitutional rights of the accused, it can be seen on our 1987 Constitution, specifically on Article 3, Bill of Rights. So, it provides the following rights. So, Section 16, so for example, all persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Of course, every person has the right of a speedy disposition of the cases because there's a saying that justice delay is justice denied. So that is for section 16. Then number 2 is section 14, paragraph 1. Number 3 is section 13. And number 4 is section 14, paragraph 2. Number 5, section 17. And under number 5, we also have section 12, paragraph 1, 2, and 3. And then number 6, we have section 19, paragraph 1. And then number 7, we have section 21. And number 8, we have section 11. So, you can, I will no longer discuss each section. You can refer to your caudal. And then for the statutory rights of the accused, just refer to section 1, rule 115 of the revised rules on criminal procedure. So let us now proceed to waiver of rights. So generally, rights may be waived provided that the waiver is not contrary to law, public order, public policy, morals, and good custom. Thus, the accused may waive some of the rights granted to him under the Constitution and under the prevailing statutes, except those which by reason of law, public policy, public interest, or morals could not be waived. So, now I will mention the rights that may be waived. So the first one is the right to procedural due process. Number 2 is the right to cross-examine the witness against him. And number 3 is the right to speedy trial or to testify as a witness. So these rights may be waived. And now I will be mentioning about the rights which may not be waived. So number 1 is the rights of the accused to be informed of the nature and cause of the accusation against him. And number 2, the right which cannot be waived except in writing and in the presence of counsel, such as the right to remain silent. So the reason or principle underlying the difference between rights which may be waived and the rights which cannot be waived is that those rights which may be waived are personal, while those rights which may not be waived involve public interests which may be affected. And now let's talk about validation of penal laws. So there are various theories validating and justifying the promulgation of penal laws. So number 1 is the relative theories. So first, let's talk about relative theories. So relative theories of punishment consist of the postulates that penalties are intended for number 1, prevention to or to prevent a person from further committing a crime. Number 2, public or social defense, which is the right of the state to repel an attack against its existence. Number 3 is reformation. So when you say reformation, it means correcting faults or correcting problems. The number 4 is deterrence. It means it is an act of making something. It is an act of making someone to decide not to do something. And then number 5 is exemplarity. So it comes from the word exemplary, which means serving as an example. Then the second theory is the absolute theory. So the absolute theory expresses the concept that punishment is an act of retributive justice, to which reformation is to prevent the wrong from annihilating right, and reformation and exemplarity are just incidental. So the absolute theory combines all the theories of punishment mentioned as relative theories. And now let's talk about the theories upon which penal laws are based. So there are two theories in which penal laws are based. So number one is the classical theory, which is also known as the juristic theory. So it theorizes its theories that the basis of criminal responsibility is the human free will, and the purpose of penalty is retribution. Retribution means punishment. This is in accordance with the postulate following this theory that man is essentially a moral creature with an absolutely free will to choose between good and evil. So this theory, my God, what happened? Again. So this theory places more stress on the effect of criminal act rather than on the criminal. So it generally presumes that all crimes are the result of man's exercise of his free will, that a man should always be liable for his action. This theory endeavors to establish a direct and mechanical proportion between crime and penalty. And then the second crime is the positivist theory. It is also known as realistic theory. So it theorizes that man is subdued occasionally by strange and morbid phenomenon which constrains him to do wrong in spite of or contrary to his volition. Volition means it is the power to make your own choices or decision. Premised upon the proportion that man is primary while the deed is only secondary. It posited that crime is essentially a social and natural phenomenon, and as such, it cannot be treated and checked by the application of abstract principles of law and jurisprudence, nor can they be stopped merely by implementing penalties which were determined prior to the commission of the crime, but through a specialized and individualized treatment of the perpetrators by psychiatrists and social scientists. Penalty under this theory is justified for prevention and correction. Now let us proceed to the characteristic of criminal law. So the first characteristic of criminal law is generality or general. It means that criminal law is binding on all persons who live or sojourn in Philippine territory. This is written in Article 14 of the new Civil Code. So in a case where the accused contended that being an American citizen, he cannot be prosecuted for, much less convicted of, the crime of illegal possession of firearms because it is a constitutional right of the citizens of the United States of America to keep and bear arms without any need of applying and securing a government license therefor. So the Court of Appeals held that the Philippines is a sovereign state with the obligation and the right of every government to uphold its laws and maintain order within its domain, and with the general jurisdiction to punish persons for offenses committed within its territory, regardless of the nationality of the offender. Therefore, no foreigner enjoys in the country extraterritorial right to be exempted from its laws and jurisdiction, with the exemption of heads of states and diplomatic representatives who, by virtue of customary law of nations, are not subject to the Philippine territorial jurisdiction. So, exemptions for the generality characteristic of the criminal law will be explained further on Article 2. So, let us proceed. So, as a general rule, jurisdiction of civil courts is not affected by the military character of the accused. So, for example, the case of U.S. versus Sweet. So, the facts includes that Sweet was an employee of the U.S. Army of the Philippines. He assaulted a prisoner of war for which he was charged with the crime of physical injuries. Sweet interposed the defense that the fact that he was an employee of the U.S. military authorities deprived the court of the jurisdiction to try and punish him. It is here that the case is open to the application of the general principle that the jurisdiction of the civil tribunals is unaffected by the military or other special character of the person brought before them for trial unless controlled by express legislation to the contrary. Now let us proceed to the second characteristic of criminal law or penal laws, which is the territorial or territoriality. So criminal laws undertake to punish crimes committed within Philippine territory. So the principle of territoriality means that as a rule, penal laws of the Philippines are enforceable only within its territory. So the extent of Philippine territory for purposes of criminal law will be far more discussed on Article 2 of the Revised Penal Code, as well as its exemptions to the territorial application. So let us proceed to the third characteristic, which is prospectivity or prospective. So, a penal law cannot make an act punishable in a manner in which it was So, penal laws cannot make an act punishable in a manner which it was not punishable when committed. So, now let us talk about repeal of penal laws. So the repeal of penal laws may be express or implied, total or partial. So express repeal takes place when a subsequent law declares categorically or specifically that the acts or omission in the first law are no longer made punishable. Then the legal effect is that the crime is obliterated. Obliterated means the crime is abolished. So if a person was already convicted, he must be released, while if the case is still pending, it must be dismissed. Now in implied repeal or repelled by reenactment, it takes place when there is a law on a particular subject matter and the subsequent law is passed covering the same. So the latter being irreconcilably inconsistent with the first, such that the two laws cannot stand together, the latter must prevail. So there is also a total or absolute repeal. So when the crime punished under the repealed law has been decriminalized or repealed by a new law, hence the act or omission is no longer a crime. So there are different effects of repeal on penal law. So number 1, if the repeal makes the penalty lighter in the new law shall be applied, except when the offender is a habitual delinquent or when the new law was made not applicable to pending action or existing causes of action. So what is this habitual delinquent? So we will just discuss this topic on the next video. Then number 2, if the new law imposes a heavier penalty, the law in force at the time of the commission of the offense shall be applied. Then number 3, if the new law totally repeals the existing law so that the act was penalized under the old law is no longer punishable, the crime is obliterated. So this is the same as discussed on the express repeal. So when the repeal is absolute, the offense ceases to be criminal. So for example, the case of People versus Tamayo. So the facts is the accused was prosecuted for and convicted of a violation of an ordinance. While the case was pending appeal, the ordinance was repealed by eliminating the section under which the accused was being prosecuted. So the ruling is that the repeal is absolute. Where the repeal is absolute and not a reenactment or repeal by implication, the offense ceases to be criminal or the accused must be acquitted. I already discussed this. So, but a repeal of the penal law by its reenactment, even without a saving clause, would not destroy a criminal liability. And now let us define the twofold end of penal legislation. So the twofold end of criminal legislation is number 1, the prevention of a repetition of the offense, and number 2, warning to others who are similarly inclined. And then, how are penal laws construed? So, in the case of U.S. versus Sweet, which I already mentioned, when the law is ambiguous and there is doubt as to its proper interpretation, it shall be construed liberally in favor of the accused. So, when the language of the law is clear, the rule has no application, it must be emphasized that there is no specific provision of law which expressly provides that penal laws must be strictly construed against the state and liberally in favor of the accused. However, the Supreme Court ruled that the provisions of penal laws are construed strictly against the state, and any doubt is resolved in favor of the accused. Now, let's talk about the venue of criminal cases, or venue is a jurisdictional in criminal cases. So it is an elementary principle in criminal law and remedial law that venue in criminal cases is jurisdictional. That is, a criminal case should be filed. Oh my god, sorry, that's my dog. A criminal case should be filed in the municipality or city or province where the crime is committed. So therefore, venue is an essential element of jurisdiction, and the jurisdiction of a court over a criminal case is determined by the allegation in the complaint or information. So, for example, A kidnapped B in Cagayan de Oro City and brought the latter to Marawi City, passing through Iligan City. So the question is, where will the case of kidnapping be filed? So the answer is, it could be filed in Cagayan de Oro City or in Initao. So again, it could be filed in Cagayan de Oro City or in Initao, Misamis Oriental or Iligan City or Marawi City, since A passed by those places to enable him to bring B to Marawi City, and the essential ingredient of the crime of kidnapping, which is deprivation of liberty, occurred on those places. Now let's talk about extraterritorial jurisdiction. So extraterritorial jurisdiction refers to the juridical power again. Extraterritorial jurisdiction refers to the juridical power which extends beyond a physical or territorial limits of a particular state or country. As earlier stated, the instances wherein penal laws may be given extraterritorial applications are provided for under Article 2 of the Revised Penal Code and certain special laws. So that ends my discussion for the introduction of penal laws. Please excuse me for grammar error or mispronunciation of the words, and see you in my next video. Bye bye.